Hello, everyone. Welcome to another live Q&A. If you've joined in previously or you typically join in each week, each week I usually most times just do a live Facebook Q&A where you ask the questions. I give the answer as it relates to family law here in the state of Georgia. Today, I want to talk content specific, and I can still take some of your questions if time allows. But today I'll be talking content specific about some potential changes to the Georgia custody laws, which is currently being proposed through House Bill number 96 that is up for vote over the next few weeks. So I'll be going over that. I tried to do a video on this last week where I was going to just publish it. I recorded the whole video, and then when I played it back, I had some internet issues. And so instead of re-recording it and then also doing a Facebook Live, I said, hey, it's just best to have this conversation open and honestly with you guys, because I think it's important that you guys stay informed on, the changes that are happening in the law and like how we get to that. We have a lot of complaints. And I say we, I mean the legal community. The laws aren't fair. Child support needs to be this, custody needs to be that. The laws favor moms. The child support is not fair to dads, XYZ. But it's at these moments when we have pending legislation that's up for vote where you need to become aware, because if you want to write your local legislator, then this is the time for you to chime in and say, hey, I agree with this, or hey, I don't agree with this bill as is. And so I'm going to talk to you about it today. You can form your own opinions. You can ask your questions. I don't know how things will be. And as we get law, what happens when Georgia law changes is that us attorneys, we have to adjust, and we sometimes have to wait till case law comes out to allow us to be able to govern ourselves and be able to take examples into consideration. This morning, I actually had a conversation with the people who wrote this law. They wanted my feedback on it, and I gave them my feedback on it. I think there's some pros and cons. It's very hard to love something in totality, and it's very hard to hate something in totality. So I think this law with a few tweaks could change. But if this law passes, it will be game changing for Georgia custody law. So make sure you're sharing this, tagging somebody who needs to hear it, because y'all need to know. Now, it may not pass. Now, a similar bill was up last year. I forget, it was like House Bill 11 something. I forget the number. It did not pass last year, but it's up again with some changes. So I want to talk about, I'm going to share it on the screen. That's the easiest way for me to do it with you guys so you can see it, because everything that I always give you guys is factual. I always give you the law. I give you my opinion from time to time too, but everything that I give you as far as my advice is based in Georgia law. So I'm going to go ahead and share my screen with you guys. I'm going to make me little and the screen big. Oops, did that backwards. All right. So here it is. I got to figure out how to scroll down here. Hold on a second. Hold on. Can I scroll down? Okay. So I'm going to have to click back and forth because I can't really tell what you guys see and what I see because I'm on a different screen. But 1993 is the Georgia custody law section. That's where attorneys find their guidance to the law. 1993 is what the judges use to also make custody determinations, is what we use to give you your advice. So the first change is coming up in A1. And y'all listen to this very closely. Let me click my screen back down. Hold on. This is annoying. Okay, so the law currently reads right now in 2021, in all cases in which the custody of any child is at issue between the parents, there should be a prima facie right to the custody of the child. There should be no prima facie right to the custody of the child in the father or mother. Okay, so basically what that's saying right now, based on Georgia law, and as I say this to you guys all the time, the law says there's no presumption between mom and dad. as to who should have custody. Although we know what it looks like and what it tends to favor, most of the time the law explicitly says that there's no presumption in favor of mother or father. But if the law changes according to HB 96, it will amend to this underlying portion. In any case in which the custody of any child is at issue between parents, there should be a presumption rebuttable by clear and convincing evidence to the contrary that a child's interests are best served by equal or approximately equal parenting time with each parent. Okay, so what does that mean? Long story short, sorry guys, hold on. I put my screen down. Hold on. Long story short, that means, put my thing back up here, that the presumption of custody is going to be 50-50. Okay, the presumption means starting a custody case, just coming out the gate, no questions asked. If there's a custody case, the presumption is that the start is that parents will share 50-50 custody, physical custody. We're not talking about legal custody. I know 9 out of 10 people walking around here with joint legal custody. This is saying physical custody. That means mom and dad, or parent and parent, because we do have some same-sex parents, will share custody equally. So whether that's a week on, week off, 2 weeks on, 2 weeks off, 2-2-5 plans, whatever. That's what it's saying. That will be the presumption of the new law. But what it's saying is that by clear and convincing evidence to a contrary, you can argue that you can deviate down from that. So let's talk about what the law will be looking for. And so in order to deviate down from that, you have to find clear and convincing evidence that a parent is either not fit, not willing, or unable to participate in such an agreement. So not fit, unable, or unwilling to participate in some agreement. And so that's where the attorneys are going to come in, if they don't agree with this 50-50 parenting argument, is making the argument on the fitness, the inability to do it, or the unwillingness to do it. Because believe it or not, everybody don't want 50-50. Okay, so those will be the arguments there. So that is a major change if this bill passes. All right. So if you have questions about that, go ahead and drop them in the chat. I'm going to try to filter out your questions to this content. And then if I have time, I'll get to the rest of your questions. So that's the first change that will go forward on HB 96. Another one, which you guys won't be too concerned with, but it is actually a really big deal. So when we have family law cases, the judge, when making a custody determination, is supposed to go through all these factors. Like you see it starting here at A, B, C, D. It goes all the way down to like R. And now the court is going to have to enter findings of fact in every single case and go over every consideration and apply the facts to those considerations as to why they ruled the way they did. And so findings of facts and conclusion of law is something we attorneys ask for. We ask for it pretty much all the time, but it forces the court to be very careful in writing their court order and making their decision, because it becomes appealable at that point. We can take it to the Court of Appeals if we find that the court abused any type of discretion or whatever. So these are the elements. This is already Georgia law, the love and affection bond between kids, all that. You can see it on the screen. It's 1993 if you just want to go and read it at your own leisure. But if we continue to scroll down here, and we're looking at E, one of the considerations is the capacity and disposition of each parent to provide the child with food, clothing, medical care, day-to-day needs, and other necessary basic care, with consideration made for the potential payment of child support by the other parent. And so they're looking to take out that language. And so some parents are barely making it, being able to provide for the care of their children. The current law considers your child support payment. Hey, if you get child support, you'll probably be able to get by and provide for your child. Some people will not make it without child support. They can't get by. And now we're taking that language out, saying, no, we're not going to consider child support, but we will consider how you can provide for the child. So that's section E that is changing. All right. Then they added in provision R here. This is so huge. We talk about this all the time. So let me put my screen back up. Can y'all see it? Okay. R, Everybody look at R. This is an added provision. The desires of the child, if such child is of appropriate age and discretion. Y'all, the law currently says today you got to be 14 years old to make a decision about where you're going to live, who you want to live with, and the court can take that consideration. You changing your mind about where you want to live at 14 can trigger the statute to be a modification of custody. If you're age 11 or greater, the court can take your opinion into consideration. It's not an end-all, be-all. But now they're taking that entire portion out of the statute and changing it to the desires of a child if such a child is of appropriate age. Oh my God, what is appropriate age? I've had people tell me their 6-year-old is so mature that their 6-year-old can tell you that they don't like their mom or they don't like their dad and they want to live here and there. We hear it all the time. So this is going to open the floodgates to a lot of various ages of children talking about what they want to do and what they don't want to do. I have kids myself. I love my kids a lot, but they've told me they don't want to live with me. They want to go live with grandma or stay at their cousin's house, auntie's house, because they have a better time over there. But that doesn't mean like I'm not a good parent, right? They just like to be where they have fun. So this is going to open up the floodgates for custody litigation, taking out this provision. I'll show it to you right here. All of this crossed out is the current Georgia law. In all custody cases which a child has reached the age of 14, the child should have the right to select the parent with whom they desire to live with. That is coming out of the statute. And this whole paragraph is all about that age of election. So it's taking all of that stuff out. Okay. And so those things are the primary expected changes to the law. Get myself back big. So the presumption being 50-50 custody at the onset of a custody case. That means mom and dad coming in, sharing custody equally, physically in some way. The court having to do a finding of fact on all elements for consideration. And then the age requirement of 14 being taken out of Georgia statute and being changed to a child of suitable age, whatever that is, being able to make the decision about who they want to live with. And so these are very, very substantial changes. This is going to open our courts to a lot of modifications and a lot more custody cases being filed. All right. So if you have comments on it, I love to hear it. I have to write something in support of this bill or not in support of it, and I'm going to submit it this week. So I love your feedback. That'll help guide me in my thoughts there. Okay, I see y'all mamas are saying this is not a good idea. Let me see. Okay, I'm not skipping y'all, but I am going to put these ones up about what we're talking about. So, Malcolm, if I agree to the new 50-50 physical custody, but I do not follow the visitation plan in the letter, will that be held against me? For instance, I have 3 weekends a month, but I only see my child once a month. So visitation and custody are two different things. If you have 50-50 custody, it ain't optional for you to visit your child. Well, it's not visit, but it's not optional for you to do your parenting time with your child. We've always said with visitation, so people who do, every other weekend or whatever, that's visitation. It's a right, not an obligation. If you have parenting time, it is mandatory that you do your parenting time. You don't get the right to pick and choose when you're not going to be a parent if you have 50-50 custody. So yes, that could definitely be held against you. Okay, Christina, tell me why you think it's not good. Hey, Japhanie, who thought this was a good idea? The legislator. I don't know. Tell me your thoughts. I mean, I know what you guys are thinking, and I know the moms are in uproar more than anybody because it's typically us moms who usually walk with primary custody. So now this is kind of throwing a wrench in it. Kareem, Joy, you need to support this. I actually do support it in many ways, and I'll be completely transparent. This is what I said. I said, okay, 50-50 custody, I feel like for divorcing parents is very appropriate because we have a child who's lived in the household with both parents, and now I'm separating. The child should continue to have equal access to both parents. That's what they've known. The question I have for concern is when we have some of our legitimation cases, because some of you guys take my advice and legitimate your child when they're a baby, but a lot of you do not, or a lot of you do not know about me, do not know about your rights until your kid's like 8. And so we're legitimating 8-year-olds and 10-year-olds who don't even like know their daddy like that. And what this law says is that this person who's been absent for 10 years now gets to come in and have this child 50% of the time, even though the mother has been putting in all the work. I think that's an issue. And I think there needs to be, it needs to be addressed. Now, if we have a father who's not married to the mother and he's been active in the child's life like all this time, then absolutely same thing as the married father, because he's been there. I'm concerned about the children who have not had an opportunity to know their father and they're, older. I mean, that's a big ask. And then furthermore, 50-50 only works in certain scenarios. I'll tell you what, it usually doesn't work for the low income. I'll just be completely transparent there. It really only works if the parents live within a certain vicinity of each other. I'm talking like between 10 and 20 minutes max. Even 5 to 15 minutes is best. So you need to live close to each other. People who work regular jobs, they have good, solid schedule. They're not working crazy hours and multiple jobs. And so joint custody does not work for everyone. Even though it sounds good, it's a cute concept, it doesn't work for everyone. And making it the standard could propose a lot of issues. That's my thoughts. Christina. Well, what's a suitable age? Christina, that's a great question. And I can guarantee you that people are going to pay us a lot of money to argue what is suitable. Is it 4? Is it 6? Is it 10? I don't know. Every kid is different, right? So that's going to be a floodgate. Brill. So if it will be presumed as 50-50, what would that mean as far as legitimation action for unmarried parents? Brill, that would mean they still need to file the legitimation action because it's an initial custody action, but what you should expect to come out of that initial custody action is 50-50 custody as written, unless you, your lawyer, by clear and convincing evidence, can make the argument that it should come down from the 50-50. How does this 50-50 rule apply when children are school age? So Jonathan, like I was just saying, when we actually do these cases now under the current law, when we're doing 50-50, we're always looking for the kids and the parents to live in close vicinity. Mainly the child's school district is the best. And so when you live close to the child's school, it doesn't matter that they become school age because both parents can get the kids to and from school and do all their activities, XYZ. We have major issues when we have people crossing county lines and living 30, 40 an hour apart. It doesn't really work. And that's what I was saying is one of my concerns with the bill as presented. Right, Carmen. Carmen, how would this work if parents live in different states? Exactly. So one of my oppositions to the bill is like, okay, this is not clear enough. Obviously, you cannot do 50-50 custody in 2 different states if you have school age children. If you don't have school age children, you can think with that. But it wouldn't really work that way. Okay, Eden, I just answered that same question above. So they will take out the best interest of a child just to give a child a possible 5 to say they would like to live with the opposite parent. That is ridiculous. It is ridiculous at 5 for sure. I don't think 5 is a suitable age. I don't think 6 is a suitable age, or 7 or 8, or hell, sometimes I don't even think 14 is a suitable age, because I tell you what, probably 8 out of 10 affidavit cases with 14, 15, 16-year-olds, they submit 2 affidavits. One said, I want to live with my mom. They say, oh yeah, I want to live with my dad. And then they cancel each other out. So yeah. Okay, this is my law wife here. There is good and bad with this bill. There's never going to be a perfect bill for custody. Nope, never. And that's why you guys have us, because we have to go in and make these little arguments, because it's case by case. It depends on what you got going on. So if a father legitimate a child, it's mandatory that he spends time with that child on his visitation time. Not on visitation. No, visitation is a right. It is not an obligation. So even if he has visitation, he does not have to do his visitation time. Derek, if I want to find an attorney for nursing home negligence, where can I find one? Derek, if you call our office, our PI team can probably direct you with that. Yeah. Melania knew from 3 she didn't want to live with her dad. She loves him but doesn't want to live with him. Yeah, no, I get it completely. I think, Christina, wasn't there a period of time, I mean, even though you guys were married at one point, she was just living with you only. And so anytime a little kid, especially a baby, 1, 2, 3, 4, if they only live with one parent, that's who they're going to live with. That's who their bond is with. Would this apply to pending legitimation case? Mine is about to wrap up pretty soon. No, if it's about to wrap soon, no, this law wouldn't kick in until later on in the year. So will the others other pay child support, or will that change? And so one of the reasons this bill didn't pass last year is because it was too much. There was a wording in there about child support. So they've taken that wording out in this current proposal. And the current proposal actually specifically says that none of this proposal has anything to do with child support. Okay, that's cute. But really it does, because if we hop over to the child support statute, we would be arguing under the parenting time deviation. So even when you share 50-50 custody, guys, even if you guys equal custody, somebody has to be the non-custodial parent for various purposes, like who's going to claim the kid on taxes, school district, all that kind of stuff. So if it's not said who is the custodial parent, as the law reads right now, the lower income earning spouse is the custodial parent. And so we would want the non-custodial parent, by definition, to have a major discount or a complete reduction on child support based on spending 50-50 parenting time. On the current Georgia law, if you have 50-50 custody and you make similar income, probably going to wash out child support. But if you have 50-50 custody and there's an income disparity, meaning one person earns significantly higher than the other, that person who earns more money will still have a child support obligation despite having 50-50 custody. I like the bill because it levels the playing field for fathers that step up. I don't like if the plan is not followed to the letter of the law, it can be held against you. Yep. I think the question about visitation was about him being the one spending time versus like his mom and them. Oh yeah. Okay. Well, if you're using your time and you're giving it to your mom, like, cause my kids, I take them to my mama house. I can do that. It's my time. You can do what you want to do with your time. The law says 50-50 parenting time, but if we decide to do 75-25, we should not be penalized for it. Yeah, and you should be upfront about that in your court order and just go ahead and be 100 with it. Like I'm gonna do 75, she's gonna do 25, or vice versa, and just say that. Versus, like, because you should know, like today, like, am I willing to do 50-50? If it's no, then say no. Like, there's no front here. Just be like, I ain't trying to do all that, and don't do all that. Kareem says, how much is significantly more? I would say over probably 15,000 and up more. So if you make 40,000 and the other person makes 65,000, I think that's significant enough to have the obligation. Okay, so some of you guys are putting other questions up here. I'm going to try to go back and jump to them. Finally received the child support payment, but it was because they intercepted the stimulus check. But why am I not receiving regular payments? This was a $1,200 one in 2020. I filed back in 2014, and he was finally found in service 2019. He probably doesn't have a job where he's reporting to the Department of Labor, so they don't have anywhere to garnish it from. But if he's filing his taxes and they garnish the stimulus check, they'll probably garnish his taxes. I'm assuming there's a back pay there. All right. Sorry, I'm trying to go back and find these questions I skipped. Okay. Malcolm. My son was born and legitimized in Georgia. He now lives in Kentucky with his mom. If I wanted to do a modification, which state has jurisdiction? Um, uh, so Georgia can have jurisdiction, Malcolm. I have to see how that order was written, but usually if one parent still resides in the state, this state can still maintain jurisdiction unless Kentucky is the better forum state. So we'll probably need to do a consultation about that. I need to check out your order and then what it is you're trying to do. Like, are you trying to get primary custody, or what your goals are? But we can talk about that in a consult. Numbers on the bottom, bottom of the screen. You can call us. Can you file contempt on a Mississippi court order when we divorced in 2010 in Gwinnett? Divorce in 2010 in Gwinnett, issued our divorce, stipulated that he must follow the Mississippi order or Georgia whole jurisdiction, being it was reordered in the divorce here in Georgia. Yeah, I think you can file that in Gwinnett if I'm understanding you correctly. Mario, should I go after legitimized without a lawyer? You're never going to hear out of Joi Fairell's mouth that you should go to court on a custody case without a lawyer. Ever. Too much is at stake. Okay. All right. So it's 2:28. I have a 2:30 consultation. And so I'm going to wrap up with, if I can find my little thing to put back up here. Okay. Sure. Boom. Okay. So that's our conversation for today, just discussing HB 96. I'll let you guys know when it's voted on and if it was voted down or if it passed. Feel free to continue to comment. I'll take those comments to the legislator if they're valid. So I appreciate this conversation we've had today. Make sure you continue to follow our page, like our page. If you want to do a consultation with us, call the number on the bottom of the screen. It's 678-973-2803. You can find more about us on our website at farrellroy.com. We do family law and personal injury. Family law is divorce, custody, child support, modifications, contempt, etc. Personal injury is our auto accident cases, our slip and falls. We do our personal injury videos on Thursday. So if you have a question about that, you can drop it here if you want, but you can follow us on Thursdays and watch those videos as well. I truly appreciate all the support you continue to give our firm. Make sure you think about us first for any of your legal matters. If we can't help you, we'll try to direct you to someone who can. Be blessed. I'll see you guys next Monday at 2:00.